Hello, everyone. My name is Don Bautista. I am the Executive Director of AC Friends of Court. We assist the public, in this case, British Columbians, complete their legal forms. And this series was designed specifically to allow the heads of tribunals and the chiefs of our various courts to address the public directly, because what we have noticed when we've been doing intake for the last 2 months is the palpable increase in stress that self-represented litigants are exhibiting when we speak to them. So the series is, we're hoping to allow our interviewees to inform the public of their planning and their thinking behind the planning that they've done. Secondly, to tell the public how they are working to even the playing field, and our guest today will get into that shortly, and to share their reflections on what they're learning about what they've learned from this pandemic. Our guest today is Chief Justice Bauman, who is our Chief Justice for the province of British Columbia. He is the Chief Justice of the Court of Appeal. He also has access to Justice BC. Chief Justice, good morning. Thank you for joining us.
Good morning, Dom, and thank you for inviting me. And I just begin by congratulating you and your organization on the work you're doing with self-represented litigants. It's invaluable and very important to the judicial system in British Columbia. So thank you for empowering so many people and giving me this opportunity to reach out and speak to a broader public that sometimes I don't have that chance to do. I welcome the opportunity to speak with you today about the pressing question of how the justice system is going to serve the public. It's a question that's relevant, of course, in our everyday world, and it has been for years, but it's even more so, it's even more relevant in this challenging period that the pandemic has brought upon us. Before I start, I want to acknowledge the extraordinary pressures that British Columbians are currently experiencing. Heightened stress, job loss, other financial pressures, trying to balance work with childcare and homeschooling, and for some, illness and loss. Coupling even a so-called legal issue with any of some of these COVID-related challenges must be enormously daunting. And I understand and feel the pain. I can assure you and your audience that the Court of Appeal is devoted to ensuring access to justice in our court during this difficult period. Now more than ever, we have the public's interests in mind as the users of our system of justice. Let me say on a general level now that the court has moved as quickly as possible from a state where admittedly we were unprepared to hear appeals safely during the pandemic to our current situation where we are able to hear all matters in the Court of Appeal by video and telephone. And in that regard, we face significantly lesser challenges than my colleagues in the trial courts of this province do. Our caseload is much more amenable to the types of virtual hearings that we're implementing now. I'm thankful for that. That means that in everything we're doing now, the court doesn't need to differentiate between what it might consider urgent and non-urgent. And that's a great relief because I'm well aware that all legal disputes are important to the litigants involved. And from their perspective, they're all urgent. We're using the Zoom platform, as you may know. It's considered very user-friendly, and we've been very, very successful in conducting our appeals in that regard. Some of the security issues that were of concern have been addressed by Zoom, and as well, we're using the Zoom professional or webinar version, which doesn't permit outsiders to hijack a particular hearing, which I understand was an issue with some of the earlier adaptations. We're reaching out to ensure the public has the information it needs to keep up with these modifications and pursue their appeals. And if I may say, there's been an unprecedented amount of communication on our website. You can go to it every day and find a number of very helpful pieces that will guide the public into the processes that we're using now to hear appeals, and in some of the best practices that they might consider when they're appearing by Zoom. Indeed, they can actually see an appeal conducted by Zoom in which a self-represented litigant, as you and I were discussing off camera, demonstrated great talent in presenting their case. And it's a good example of how effective the medium can be for all litigants, including those who do not have the benefit of a lawyer in presenting their case. I also want to note that the Court of Appeal has a very robust program for referring all self-represented litigants to pro bono counsel through Access Pro Bono. So every self-represented litigant in our court is initially referred to the services of Access Pro Bono BC, where they can obtain some initial interview with a lawyer and perhaps full representation on the appeal on a pro bono basis, or alternatively on a lowered fee basis. An incredible opportunity for self-represented litigants at the appeal level in British Columbia, which I think is unprecedented in Canada. And I congratulate again, as I always have, Access Pro Bono BC for that initiative and for the registrar of our court in facilitating its implementation in the Court of Appeal for British Columbia. For those who prefer to represent themselves, as I've mentioned, the court has made great efforts to ensure there's plenty of valuable information about the COVID-related modifications. And there are other resources, as you well know, our self-help website, of course, which is maintained through the Justice Education Society, and the work your group does in helping self-represented litigants. As we make modifications to accommodate video hearings and advanced electronic filing, we are evaluating our practices and improving them as we go. And just as a side note, electronic filing, e-filing, is critical to our ability to offer virtual hearings and to facilitate the actual holding of those hearings. And again, if there are problems with the e-filing experienced by any of your listeners, we direct you to assets that might be of assistance to you in that regard on our website. Most importantly, because all of this in a vacuum is useless, the court's gathering information from participants. And I can say we've received very positive feedback, including from self-represented persons. And it's been suggested that a hearing by video is far more accessible, more user-friendly, and less intimidating than our usual in-person appeals process. For those of your listeners who have any security issues or privacy issues, the material on our website will direct you to a form that we ask you to fill out. It's not an intrusive form in asking you to indicate if you do have privacy concerns that we can try to address through the process. So there it is. That's generally what we're doing. I think we've been successful. We could use more support on infrastructure, and the government's keenly aware of that fact and working with us to address it. Thank you.
Thank you, Chief Justice. So I have before you 4 questions, and I'll sort of go through the first one. I'll start with the first one by saying it's been 2 months. Your courts have instituted changes, but I suspect that there will be more to come. But I'm not so worried about the minutia of, the changes that you're making, but I wanted to get a sense of what lessons you gleaned from what's happened so far and how you're going to sort of take advantage of these lessons to address the bigger access to justice issues in light of the pandemic.
Well, I would start by saying that the experience has confirmed, if we didn't know it before, we certainly do now, the importance of communication. Communication with our users, litigants, lawyers, et cetera. Government. Communication is critical in times like these. Indeed, it's critical at all times. And we've reached out to the public, to lawyers and to government and to other courts and organizations from the outset about what we are doing. And that communication with other courts across the country, for example, has been invaluable in allowing us to see what other courts are doing, how they're addressing issues, novel ideas that they're pioneering. And it's a great opportunity, if you like, there's a silver lining to the crisis, to learn from others and to reach out and communicate with them about what we're trying. We couldn't come as far as we've come without sharing information, listening to the feedback, and addressing the concerns that we hear. In that sense, I would say that the court is now no longer unseen nor unheard, I hope, but rather has robustly communicated every step of the way, especially considering our limited resources. Another lesson I've learned is that people who make up the justice system, and I include self-represented litigants, of course, in that group, are far more flexible and adaptable than many of us thought before the pandemic. Within a few short weeks, we see judges, lawyers, self-represented litigants, court staff, the media, and others shift to doing hearings by video, which we've never done before in the 110-year history of our court. And that gives me hope. I've said many times that if we're going to address the access to justice problem, we need to try new things, to be collaborative, to experiment, and importantly, to take risks. Obviously, video hearings aren't going to solve the A to J situation. We simply can't add on digital processes to the existing process and expect all of our problems to go away. They go deeper than that. But the experience is showing us that everyone can make cultural changes, that they're attainable. And it's too bad, I would suggest, unfortunately, that it takes a pandemic to get us here. But my hope is that we can use this experience to move forward in a new way. Thank you.
Much has been said about technology, how it's been equated as the move that's been identified as the pivot for the courts. Still, we view it as an important, while it's viewed as an important facet, it shouldn't be a hurdle. And there are two groups that come to mind, Chief Justice. One are those who cannot use a computer. A significant subset of our clients just can't. And in the past, they've relied on trusted intermediaries like libraries and community centers to communicate with the courts through their submissions. That's not available anymore. What can they do?
Well, you know, you're right. We've greatly expanded e-filing, which for most self-represented litigants we find is an improvement. We find most people find it easier to send documents over the internet rather than using a post office or attending the registry in person. That's for most people. But we understand, of course, that there are people who don't use a computer. We understand, of course, that there are bandwidth issues and the ability to dedicate to purchase computer time to do some of these applications. So we still have the usual methods and we're not throwing them out. They're still available. People can call the registry, and our hardworking staff in the registry will try to work with the person to figure out a method that works for them, whether that's mail, our physical drop box, or another means. And likewise, in general, the court continues to accommodate anybody who doesn't use a computer, and we're well situated to do so, since, of course, we've been largely paper-based until essentially a few weeks ago. So we're new to this. We haven't left the old ways completely, and surely we have to accommodate those in our society who aren't able to avail themselves of these modern technological assistance.
The other group that we see a lot of are family law clients. Within that subset, many of them are victims of gendered violence. Can you sort of speak to that point and how you see them transacting with your court?
Yeah, we're very sensitive. The Court of Appeal is a little different. We don't often have witnesses, for example, or and a person who's represented need not attend in court itself. But we're looking very carefully at all of our processes to determine which ones should continue post-COVID. Specifically, we're examining modifications from the user's perspective to determine what's making life easier for people, quicker and cheaper, and how can their personal security concerns be addressed. I've mentioned the form that's on our website that invites litigants to tell us any particular problems, and we're extremely sensitive to those issues. Indeed, we see not similar issues, but other privacy issues on the criminal side, which we have to address as well. So absolutely, it's a brave new world. But the fact is we can't abandon the need for making our courtrooms safe places for all litigants where they have a sense of security when they come to court. So that's a very important consideration that we have top of mind.
Chief, can you talk about the case, the virtual hearing that you posted on your website recently?
It's an example of the technology at work. It's one of our earlier hearings. I had done an earlier hearing and sitting as the Yukon Court of Appeal. Let me just tell you that one because I think it gives you a chance, an insight into the breadth of the technology. We sit as the Yukon Court of Appeal. Whenever I do that, I try to ensure that we have a northern judge, usually from Northwest Territories or Nunavut, sitting with us so that we have that context to apply. So on this particular hearing, it was a criminal matter. It was a sentence appeal by the Crown. 2 judges sat in their offices in Vancouver on Zoom. 2 lawyers, the Crown and the defense lawyer, were in Whitehorse on their computers on Zoom. And the 3rd judge was in Iqaluit. An incredible example, and it was clerked from Vancouver in another courtroom. So an incredible example of bringing people across the continent together to dispense justice in a particular case. That lasted for 3 hours, and we were able to give an oral judgment at the conclusion. So justice stretching across thousands of miles, quite an incredible experience. We have that example of the British Columbia Court of Appeal sitting on the website now, and as a matter of fact, you can go to it to see an example, and it includes a self-represented litigant. You can see how the arguments were made. It seemed to me forcefully, effectively. Everybody saw each other. The sound was good. The arguments came across almost as though you were in a courtroom hearing them. As well, members of the public can now go to our website any day to see the court list and to simply click on and attend a hearing by Zoom themselves without the previous signing in that we required because we were concerned with bandwidth issues and whether we could accommodate all listeners. We found that that was not a realistic concern, and so now you can simply click in to any hearing you want in the Court of Appeal and see it in real time. So again, another example wasn't happening 4 weeks ago or 5 weeks ago. Another example of the court being able to respond quickly and judges and litigants responding quickly as well.
Thank you, Chief Justice. Let me move on to my 3rd question, and this centers around procedural fairness. And, you know, I said to you earlier off camera how I looked at the case that was on your website, and I watched most of it in last night and this morning. And it was quite noticeable how the judge, one judge, went out of their way to try and sort of guide the self-represented litigant who was articulate but still needed guidance. And of course, I chuckled because there was a memo from your office that says, look, if we're doing this, no need to gown, and yet the lawyers were still gowned. So the playing field is not quite there yet. And I wondered if you had any thoughts moving forward. What else are you guys doing to try and even the playing field?
Well, let me assure you that the fact that one lawyer might be gowned and the in-person litigant is not doesn't make for an uneven playing field. We recognize that the lawyers gown as part of their professional courtesy to the court, although they're told that they need not, and the litigant comes before the court as the litigant is. So there's no unevenness from our perspective in that scenario. But yes, Justice Hunter was demonstrating what all judges should be doing, I hope, to assist self-represented litigants within the confines of proper assistance. And that is to try to direct them to what the relevant issues are before the court and where the court is having difficulty with a particular issue so that they know that and are able to address it for the court. I think I've been responded to your question. I also say, of course, that with the advent of universal Zoom hearings, we're not simply restricting ourselves to urgent matters. We're hearing all matters that come before us in the hopes that we can clear the backlog that was relatively modest in the Court of Appeal. We are sitting 3 extra weeks in July on a voluntary basis to clear that backlog, and we hope to have it under control by then.
I joked about it last time, Chief Justice, but be careful of what you wish for. By the time we post this YouTube video, people will actually hear that July seems to be a good month. I joke about this, but internally, we are actually very concerned that legal matters for many have kind of been put on pause, but we know that there's going to be a deluge of files coming in through our doors. And so it's somewhat, I feel good that you guys are caught up and are prepared. 3 extra sittings is wonderful, but can I just ask you about sort of the time? Is there some thinking within the courts that you might hold it outside of what I put in quotes, the traditional sort of Court of Appeal hours?
Well, are you saying extend our time?
Well, in a more asynchronous way. If they're virtual, does it have to be, can it be done in the evenings, on the weekends? Have you guys talked about that? Sorry, Chief, I thought about this morning and I said,
yeah, we haven't talked about that. You know, certainly from an emergency perspective, we're prepared to sit at any time. But we haven't talked, to be frank, about evening sittings for the Court of Appeal. I know the lower courts have experimented with some of those issues. Indeed, the provincial court did. I'm not sure that they were that many people took them up on it, but it's always an issue. Let me just talk about the court day. I've talked about this before. Quite apart from when the court day is, whether it's an evening or a weekend or during traditional hours, the fact is that 4.5 hours of court for the participants is quite a heavy day. I know it never sounds that way when you're used to working 10 or 12 hours a day, as I know many of your listeners are. But the fact is the amount of concentration involved, especially where witnesses are taking the stand, takes quite a toll on those listening. And you ask any jury, and they'll tell you that 4 hours a day is quite enough. But sure, we have to be able to respond to the needs of litigants, and perhaps changing our hours to accommodate litigants is something we should be discussing.
Chief, that leads me to my final question. Self-represented litigants view lawyers as powerful insiders. And there's ample evidence that, because it's when everyone talks about the very, very strong relationship these days, how bar associations and our regulators have sort of worked really hard to try and get messaging out to make adjustments to everything. I am heartened to, when I look at your website and you publish COVID-19 notices, it doesn't distinguish between the public or the profession. It just says notices. And that type of messaging, I wanted to say to you is quite remarkable. But for the average person, what is it that they can do to sort of write you? I mean, earlier you said now you're allowing people to evaluate their virtual hearings, their experience with that. Is there anything else that they can do? How do they write you?
Well, my email address is robert.bauman@bccourts.ca. And I've always been open to receiving correspondence, not on particular appeals, because your listeners will appreciate that I can't get into that. But for members of the public to tell me what's on their mind, generally that avenue is available, as is Access BC, Access to Justice BC rather. Our website invites public input there. And that outreach is extremely important. Without it, as you said, we're unseen, we're unheard, and it creates a barrier to our ability to hear from the public, whose trust and confidence in our institution is absolutely critical. And I don't think I can invite the public to trust and have confidence in our institution if I'm not hearing from them.
Thank you, Chief Justice. The last time I saw you in person was at the Legal Hackathon. And I was recalling the remarks that you said then, and it rings true. But I think it may be that the pandemic has now made you a very serious player, that I think what would happen if the courts actually competed in the next Legal Hackathon, because the pandemic has been an ongoing hackathon for all the judicial institutions. So I want to thank you for this conversation. Last word belongs to you. Is there anything else you want to tell our listeners?
No, I think, thank you again, Dom, for the opportunity. I just want to say that these opportunities to communicate with the broader public are extremely important. In earlier times, we didn't, judges were removed from the greater public, and we now know that that's not the way to engage. So I welcome these kinds of opportunities, and I welcome the public debate we have about access to our courts and where we are failing the public. But I'd also wouldn't mind hearing the odd time where we're serving the public and are perceived to be doing so. So thanks for the opportunity. Collaboration with groups like yours is critical to advancing access to justice in British Columbia. And I congratulate you again for your work in that regard.
Well, on that note, Chief Justice, have a wonderful day, and we'll see you around very soon.
Thank you very much, Tom.
Take care.
You too.